Hi, this is Evan Langert with the Langert Commercial Group. Let's talk today about assignment and subletting. During the course of any tenant's lease, there might arise any number of reasons why that tenant wants to assign its lease to another party, or perhaps to sublease the premises to another party. Without getting into an exhaustive list of the reasons that someone might want to do that, let's just get into a few. First, maybe a tenant just wants to retire. They've been there for a long time. They're tired of the business, but they're successful. Maybe they're going to sell it to someone else. Maybe they're going to bring their kids in to run and own the business, or some other family member. Maybe there's been a medical emergency in the family, or even to the principal or the tenant themselves, and they can't attend to the business anymore. Maybe someone's made a nice offer to purchase the business, and the lease is just one more asset that gets transferred over to the new owner during the course of the sale. These are all reasons why someone might want to assign or to sublease. Now let's take a step back and look at how landlords typically view these things and how tenants typically view these things, and perhaps how we might be able to come to a solution or two. A lot of landlords look at things and say, this is my property, I bought it, I made the investment. I want to control who I lease to. After all, when you signed your lease, I elected to lease to you. I could have said, no, thanks, I don't want that use in my building. Or I don't want somebody with the level of financial wherewithal that's been presented to me in the building. So why should I have you be able to just transfer it over to somebody else who may not meet my criteria? A landlord might have an office building that they want to be a professional building. They might only want CPAs and attorneys and engineers, or a medical building where they only want doctors, or maybe even only certain types of doctors. In a shopping center, there's something called tenant mix, which is widely practiced and is both art and science. And what that says is, as the owner of a shopping center, I increase the number of visitors to my shopping center, and I increase the welfare of all the tenants in the shopping center if I have this particular mix of tenants in here. And if I upset that mix, everyone in my shopping center, including me, is going to suffer. So that comes into play as well. And so a landlord's language may say, and often does say, tenant may not assign or sublease this lease without landlord's written permission, which may be withheld in landlord's sole and absolute discretion. So what does that mean? That means the landlord can turn your assignment or your sublease down for any reason or no reason. They may not like you. They could turn it down for that reason. You may have worn a yellow tie on Thursday and they hate yellow, or they might just be in a bad mood. Their breakfast upset their stomach. But with that language, you can be turned down for any reason. Tenants, they like to have maximum flexibility. A tenant thinks, I lease the space, I'm paying money for it, I want out, I found someone else who will take the space, I should be able to assign it. I don't even think I need your permission. Well, that's not going to fly with landlords. So what do we do in these situations? Well, one thing that I try to do often is to just have the landlord be required to be reasonable. So as I said before, the language often says that they can refuse you in their sole and absolute discretion. If I can get them to change that to say that their approval cannot be unreasonably withheld, conditioned, or delayed, then they can't just turn it down for any reason. As a matter of fact, what happens there is it gets turned into an objective standard. If you go to court on the matter, a judge will, in his or her mind, come up with an imaginary reasonable landlord and say the tenant wanted to assign the lease to this party. Would a reasonable landlord have turned that down, or would a reasonable landlord have let that through? And that will be the standard that gets applied to your landlord. So that's a big help, and that's a big step up for any tenant. What landlords might also do is they might make a list of categories of tenants that you can't lease to, or sublease or assign to. And those lists generally can be very long, and they might consist of tenants whose uses require too much parking, like a theater or a bowling alley or any number of things that require a ton of parking. and if the center, especially if the center doesn't have that much parking or excess parking. Other people that tend to make that list are uses that are non-traditional retail. For instance, sometimes you'll go into a center and you'll see office type uses or pseudo office type uses. And there are a lot of retail landlords that don't want that. And then there are other uses in an office building or a shopping center where the landlord says, my building has a certain cachet within the community and people consider it to be an A building or an A shopping center. And so I don't want C or D tenants in there. And I'll leave that discussion for a later time as to what constitutes a C or a D tenant. But I think in your imagination, you can probably imagine what some of those are. So those are some of the ways that this gets solved between landlord and tenant. It's important to address this up front. As always with my videos, I don't intend to give any particular brokerage or legal advice to anyone in particular. This is general information for your consideration. If you want to talk further about your specific situation or about your lease, I can be reached at 443-529-0505. Again, 443-529-0505, or you can email me at elangert@thelangertgroup.com. That's elangert@thelangertgroup.com. Elangert is E-L-A-N as in Nathan, G-E-R, T as in Thomas. As always, have a great day and God bless you.